This might actually be the first step to true transparency in this case. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. The last document that we saw in the Idaho 4 case was one that we were sort of surprised to see because Judge Hippler has made it a very apparent point that he doesn't like all the privacy and all the secrecy in this case, but still things seem to be being filed under seal. Now, there was a plethora, well over 40 filings that posted on 2/24, so February 24th, over on the case summary sheet. Now, these are just titles. We do not have any of the inside documents for these titles. So all of the conversations that you're hearing all over the place at this point when it comes to the autism disorder conversation, it's all coming from these titles. We have no true information. Everything is temporarily sealed. Now, the judge has put an order out, and it looks like he is telling the state that we're not going to be doing this situation anymore where everything in whole is getting filed under seal. You're going to start using redactions so that things can be filed publicly. At least that's how I'm taking my first little skim through. Let's go ahead and pull these documents up. Now we're going to open this one first because this order right here was actually signed on 2/27/25. And you're going to see that the judge's order that we're going to go over next was signed today. Like he wrote it and signed it today. Today is March the 3rd. Now, this one is an order for the sealing of the defendant's motion in limine regarding the inconclusive data and the statistical analysis information. And it says under seal, but then it looks like Judge Hippler went in and wrote some stuff on this. I read, I go through a lot of medical records. I read a lot of doctor writing in my day job, and this is difficult for me to read. I can figure out some of the words, but some of them I'm just not really quite sure. So we're gonna look at it. We're gonna look at it up close here in just a second. Now, this states the court having before it the motion to file defendant's motion in limine regarding inconclusive data and the statistical analysis under seal and good cause of hearing. Now, therefore, it is hereby ordered the defendant's motion in limine regarding the inconclusive data and the statistical analysis shall be sealed pursuant to ICR 32I and IC 741241B and C. But you're going to see here in a minute that there is a difference in the way that Judge Hippler now writes this order because he's basically done with all documents being completely sealed in whole. He wants there to be more public information and just certain things that are in those documents be redacted because it's not the entire document that needs to be completely taken away from public access. It's just certain pieces is how I'm sort of getting that order from just skimming through it really quickly, but we're going to go through it in whole here in just a second. Now, I'm trying to figure out what this says. I'm not really quite sure. I don't know what this word is, but I think this is believe the documents regarding something grand jury testimony, which is exempt from disclosure. So there must be something in these things regarding something from the grand jury testimony. That's the only thing I can really get from that. But there's like 2 words or so in there that I'm just not really quite sure what it says. Okay, now this is the order. This is the order where, again, it sounds like he doesn't want full documents in whole filed under seal anymore. He wants them to just redact what needs to be redacted and quit the boo-boo is how it sounds. Okay. Order regarding sealing or redacting filings. The party's pervasive practice of filing material under seal in this case has become the norm rather than the exception. Rather than seeking to redact discrete sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain or is simply not confidential or sensitive. So he's saying they're playing secrets for no reason because he already knows that this information is already out there. First footnote. Likewise, the parties seek to seal a document that contains the entirety of the information sought to be sealed in the title of the document, as in exercise in fertility, because the name of the document, which contains the sensitive information, once filed, is on the public available register of actions. So there's stuff in these titles that should be information that's secret, but it's in the title. So we're seeing the sensitive secret information anyway. So they're basically doing it for nothing. It's all been secret for nothing. And the secrecy is what's caused the majority of the issues. So many theories and so many things could calm down. The big dumpster fire could cease to exist if they would stop being so secret about things that do not need to be secret. There's way too many unanswered questions in this case that this far down the line, we should have answers to. And it's not anything that would jeopardize the case. It's just straight up information that would make sense. Like, did Xana and Ethan, or let's just leave it at Xana, did Xana actually get the DoorDash? Was the DoorDash left at the door? Did somebody else that was not Xana open the door and take the DoorDash from the DoorDasher? What is the freaking situation with the DoorDash? And why are we not allowed to know if she actually got the food and had began sitting down and eating it or not? Why are we not allowed to know that? Stuff like that. Where was Dylan before the situation? Why is her whereabouts and technically everywhere where Bethany was, honestly, why is there so much secrecy in the before timelines? Why do we have gaps for Xana and Ethan? Why are there questions about the direct timeline that don't have anything to do with the case facts? Why? There shouldn't be anything like that happening right now. This approach runs counter to the public's First Amendment rights to know what is going on in its courts. State versus Clapp from 2020 is what they're referencing here. Consequently, the court will look with scrutiny on requests to seal documents simply because they purportedly contain facts that are not public, but that nonetheless will likely come into evidence. I mean, they do a good enough job giving us technically sensitive gag order worthy material in court pretty much every freaking hearing. I mean, the state does it too. The state does it a lot. The Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied, including through the redaction and sealing of records. To warrant sealing or redaction, the material must meet specific criteria set forth in ICAR 32I so as to allow the court to make the findings necessary to justify its decision to withdraw the material from the public purview. Moving forward, the court will require the parties to adhere closely to this rule and only seek to seal and or redact material as provided thereunder. In addition, all proposed orders to seal or redact must specify the basis under ICAR 32I3A for which the sealing or redaction is warranted. A bare citation to the rule or conclusory summary without an individualized, rigorous, factual, and legal analysis of the basis for seeking to have documents sealed will result in a rejection of the request. See, they can't just say, oh, I want this sealed, so here's the motion to where I'm asking for it to be sealed. They have to give the details and for what. It has to make sense. It has to follow the rules because they're not sealing just every little thing anymore. He's showing that now he's really done with it. Like, he said it in court before, and now he's making it a reality. Further, the parties must also seek the least restrictive method to protect information that should be or is exempt from disclosure. For example, despite the court's concerns being expressed previously, the state continues to seek broad orders sealing entire documents to protect the identity of individuals rather than simply using initials or requesting that a redacted version be made public that discloses only initials. Accordingly, the state's request to seal filings writ whole are denied, except as otherwise noted regarding certain exhibits containing grand jury testimony or other exempt records. Rather, those filings have been redacted by the court to refer to certain individuals by initials or family members of the deceased victims by their nature of the relationship, example, brother, rather than by name. Initial it or not, honey baby, we're going to know all about who it's about. The original filing will be sealed and the redacted versions will be made public. In addition, the court has redacted portions of defendants' filings that contain grand jury testimony. Well, that tells us at least that the defendant has information from the grand jury testimony and the transcripts, because that's been a huge conversation for a super long time. And also was another thing that Jennings mentioned in those two sessions that we had on the 23rd and 24th of January that Anne didn't even bring up. And Jennings just decided to blurt out something about the grand jury transcripts then too. Like I said, the state really likes to just like blurt out information. They don't even realize what they're doing, I don't think, honestly. Now, there has been updates to the case summary as well, a few more titles, but nothing that we can really get anything else from. We've really gone over the majority of the newest information. We have the subpoena ducis tecum that I told you guys about in a community post a few days ago, the filing order for the temporary sealing, which we've already gone over. We've gone over this one. This is the order that we just went over just now. Now, we have a motion to seal notice of filing signed and notarized affidavit. That tells me that somebody else wrote an affidavit and it's in there. I wonder who it is. I wonder if it's something from one of the witnesses or if it's something from an expert witness, but this is interesting to me. Then we have a motion for leave to file additional expert witness disclosures, and then we have some information. It looks like 3 different filings when it comes to the defense's second supplemental request for discovery regarding expert witnesses. Or at least I believe it's for the defense because it says second supplemental response. And when it comes to what the state is supposed to be responding to, we're up to like 22, I believe it is. So I'm pretty sure that one's for the defense. I could be wrong, but it's probably for the defense. So yeah, he finally put what he said in court in black and white text, signed it and filed it, and he's telling them no more filing things wholly. Go in, put your initials, redact whatever you're saying is sensitive. We're not doing this entire document, entire filing being sealed and completely secret anymore. And I'm glad that he's finally doing this. We've been waiting for something like this for a while. Now, I don't know why, if he's basically claiming that all the crap that they've been trying to seal and keep so hush hush is stuff that's already out there, why they don't just lift the freaking gag order. Like, seriously, why not just lift the gag order and let us actually get the information? You still have the right as the court to not disclose what you don't want to disclose by keeping those things sealed. But lifting the gag order would mean that a lot of this crap, a lot of this insanity that keeps happening could stop. We could get some real truth. We could knock out a couple of the crazy theories. We might even actually make some of the timeline make sense. Because right now it doesn't make any sense at all. Why can't we know what Dylan and Bethany know? If the defense and the state already know whatever the hell this is, why is it being kept so secret? What's going to freaking change just because the truth is out there to the public? Somebody make it make sense. Like, I don't want to hear the legal law or it's because this is the law. No, make it make logical sense at this point that we still have all this secrecy with the judge literally telling us everything they're trying to keep secret's already out there anyway. It's completely pointless. Okay. Like, I want to know what you guys feel about that entire thing because that's interesting to me. And not only is it already out there, but he's like, y'all are letting them know in the title what it's all about. So all of this is for nothing. Like, it's insane. Insane. Let me know how you guys are feeling about this finally having an order behind it when it comes to getting rid of some of the freaking secrecy. Let me know how you guys are feeling. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you are not subscribed already. And please don't forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.